Hi everyone. Our topic for today is about Title II of the Revised Penal Code. And Title II of the Revised Penal Code is about crimes against the fundamental laws of the state. And when we say fundamental law, we are actually referring to the Constitution. So as we continue with the discussion on Title II, you will notice that the felonies defined and punished under Title II are mostly violation against your constitutional rights as provided in the Bill of Rights, to be specific. So first you have there arbitrary detention under Article 124. Any public officer or employee who, without legal grounds, detains a person shall suffer the penalty of arresto mayor maximum to prison correctional minimum if the detention has not exceeded 3 days. The penalty of prison correctional medium and maximum periods if the detention has continued more than 3 but not more than 15 days. And the penalty will be prison mayor if the detention has continued for more than 15 days, but not more than 6 months. And if the detention shall have exceeded 6 months, then the penalty of reclusion temporal will be imposed upon the offender. Now, if you notice in Article 124, the offender here is any public officer or employee, and that would be one of the elements of the crime. And when we say any public officer or employee, are all public officer or employee liable for arbitrary detention? Or who are these public officer or employee referred to under Article 124? Now, to the person liable under Article 124 are only public officer or employee who is vested with jurisdiction to detain or order the arrest or detention of a person. In other words, not all public officer or employee can be made liable for arbitrary detention under Article 124. If a public officer or employee is not vested with jurisdiction or authority to order the arrest and detention of another person, then that public officer or employee can only be made liable for illegal detention because he is acting in his private capacity. Now, if you notice, the detention there is without legal ground. In other words, he orders the arrest of another without any legal basis. And the penalty to be imposed upon him depends upon the period of detention. So to reiterate, you have there the elements of the crime. The offender is a public officer or employee, and as what we have stated a while ago, it is referring to that public officer vested with authority to detain or order the detention of a person accused of a crime, but when they detain a person, they have no legal grounds therefore. And to reiterate, if that public officer has no authority to detain, then that public officer can only be made liable for illegal detention because he is acting in his private capacity and not arbitrary detention under Article 124. However, you have their private individuals, and this would include public officer who has no authority to detain or is not vested with authority to detain or order the arrest of another person, but because of conspiracy, they conspired with public officers who are vested with authority to detain, then that would be the only time that they can also be made liable under Article 124. The next question would be, when shall there be detention? Is it required that the offended party will be placed in an enclosure? Now, detention is defined as the actual confinement of a person in an enclosure or in any manner detaining and depriving him of his liberty. In other words, he may be detained in an enclosure, but there are also circumstances that even if the offended party is not placed in an enclosure, there is still deprivation of his liberty, hence detention is present. Now, when shall there be legal grounds for the detention of a person? There are only two instances where legal grounds of detention is present. You have there, first, commission of a crime. Of course, you will be detained. Second, if you are there suffering from illness or ailment requiring detention, then those two instances are legal grounds for detention. In other words, if the person has not committed any ground, or at least there is no reasonable ground for suspicion that he has committed a crime, or when he is not suffering from violent insanity or any other ailment requiring compulsory confinement in a hospital, then the detention is without legal ground. Arrest without a warrant is the usual cause of arbitrary detention. In other words, we can only arrest a person by virtue of a warrant of arrest or arrest warrant. But you might be asking, how about if in my presence a person is committing a crime? Do I have to go to court and secure the issuance of a warrant of arrest? You have their exceptions, okay? Actually, that scenario falls under one of the circumstances where warrantless arrest is considered to be lawful. In other words, you can cause the arrest of the person even without the arrest because under the law, it is considered to be lawful. So what are the circumstances where warrantless arrest is considered to be lawful? So you have there, when in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. In other words, the police officer or peace officer or any private person for that matter can arrest a person even without a warrant of arrest when he witnessed the commission of the crime by the accused. This is also commonly known as in flagrante delicto arrest. So to illustrate in flagrante delicto, you saw him, you saw A box B. Of course, you can arrest A because he has just committed a crime. Or actually committing, he is still boxing. That's why you prevented him from further boxing B. And then the other one is attempting to commit. So he is about to commit. In other words, you can prevent him from committing or consummating the felony. You can already arrest him because at that point in time, he is already committing a felony, though still in the attempted stage. So that is in flagrante delicto arrest. You can cause his arrest even without a warrant, without being or without incurring any criminal liability under Article 124. Another circumstance where lawful warrantless arrest is allowed, you have there, when an offense has in fact just been committed and he has probable cause to believe, based on personal knowledge of facts and circumstances, that the person to be arrested has committed it. This is also known as hot pursuit. So to illustrate this one, we have it as A stabbed B. And after stabbing B, A fled. And here comes the responding police officer, for example. They saw A injured. They saw the injury, the wound suffered by B. And now they investigate and now they acquire personal knowledge as to the commission of the crime by seeing the wound itself plus the information given by B to them. And right then and there, they pursue A. If they arrested A, in that particular instance, the arrest there is considered to be hot pursuit arrest. They can cause the arrest of A even without the presence or the issuance of a warrant of arrest. Now, if the person committed a crime or he has fled, if we would not allow this as a lawful warrantless arrest, then it would be very hard to seek justice and made these persons or offenders answer for their wrongdoings. Okay? So those are instances where lawful warrantless arrest is allowed. And the last circumstance is an arrest of an escapee. When the person to be arrested is a prisoner who has escaped from a penal establishment or a place where he is serving final judgment, or temporarily confined while his case is pending, or has escaped while being transferred from one confinement or another. So, under the third paragraph, this presupposes that an information is already filed against the accused and is pending before the court. So, arresting an escape, no need of a warrant of arrest to cause his rearrest. For purposes, I think you have heard already of inquest proceeding. In the prosecutor's office, what is subjected to an inquest proceeding are those warrantless arrests falling under paragraphs 1 and 2. So after the police officer would cause the arrest of a person either in flagrante or hot pursuit, they would prepare the necessary documents and file the complaint before the prosecutor's office. So in the prosecutor's office, when the prosecutor received the complaint as well as the supporting documents, he or she has to evaluate if the arrest of the person falls under warrantless arrest. Because if it falls under lawful warrantless arrest, then the prosecutor can proceed with the inquest proceeding. And what is that inquest proceeding? It is actually a proceeding which is summary in nature for purposes of determining whether there is probable cause against the accused. So if there is probable cause, then information shall be filed against the offender to the court. If there is none, then the prosecutor at that level can dismiss the case against the arrested person. Now let us say that there is no, or the arrest of the accused does not fall to paragraphs 1 and 2. In other words, it cannot be considered as in flagrante. It cannot be considered as hot pursuit. What shall the prosecutor do? We will release the arrested person and the charges against him shall be subjected to regular preliminary investigation because he cannot be arrested without a warrant, or it's because his arrest does not fall to the lawful warrantless arrest provided for by law. So, again, for the meantime, he will be released, but the complaint or the charges against him shall be subjected to regular preliminary investigation. So in a regular preliminary investigation, the respondent there or the arrested person will be given an opportunity to submit his counter affidavit, and the prosecutor has within 60 days within which to terminate the preliminary investigation. Whether the offender, the respondent, will submit a counter affidavit or not, within 60 days the prosecutor has to resolve the case. If the prosecutor finds probable cause, then an information will be filed against the offender to the court, and it would now be up to the court when he received the information to evaluate the same, and that would be the only time. If he is convinced that there is also probable cause, then he shall issue a warrant of arrest, and that warrant of arrest would now be the legal basis to cause the arrest of the offender. Now what if after we do PI, preliminary investigation, we are not convinced that there is probable cause? We can dismiss the case against the offender. So it will not reach the court anymore because at our level, we already dismiss the complaint against the accused. So that is arbitrary detention. What about Article 125? Delay in the delivery of detained persons to the proper judicial authorities. The penalties provided in the next preceding article, so we are referring to Article 125, shall be imposed upon any public officer or employee who shall detain any person for some legal ground and shall fail to deliver such person to the proper judicial authorities within the period of 12 hours if the charge to which the accused was arrested is punishable by light penalties or its equivalent. Within 18 hours, if the crime or offenses committed by the arrested person is punishable by correctional penalties or their equivalent. And 36 hours if the complaint or the offense committed by the arrested person carries with it a penalty which is afflictive or capital. In every case, the person detained shall be informed of the cause of his detention and shall be allowed upon his request to communicate and confer at any time with his attorney or counsel. Now, how does Article 125 different from 124? Now, as far as the offender is concerned, they are the same. Public officer or employee vested with authority to detain or order the arrest of a person. While in Article 124, the arrest is without legal ground, in 125, the detention here is for some legal ground. There is legal ground for the arrest or the detention of the accused. And again, what is that legal ground? Commission of the crime and violent insanity requiring or ailment requiring his detention in a hospital or any institution. Now, what makes him liable under Article 125 when we say that the detention is for some legal ground? Look at the third element, that he fails to deliver such person to the proper judicial authorities within 12, 18, 36 hours. So the overt act here in Article 125 is his failure to deliver. And when we say failure to deliver, what does it mean? Deliver him physically to court? Okay. The failure to deliver there is actually just referring to um, the making of an accusation or charge or filing of information against the person arrested with the corresponding court or judge. Now remember the example that I have, the illustration I gave you a while ago with respect to lawful warrantless arrest under paragraph 1 and 2, and they will be brought to the prosecutor's office for the conduct of inquest proceeding. So if the prosecutor is convinced that there is probable cause, then we prepare the information to be filed against the accused in court. And that filing is actually the delivery referred to here in 125. But you might be asking, but what if it was Saturday and the courts are closed? Okay, so the proper question would be, when shall this failure to deliver under Article 125 commence to run? Okay, take note of paragraph 1 and 2 under lawful warrantless arrest. In flagrante delicto, it presupposes that after the commission of the crime, you cause the arrest of the offender right then and there. So the 12, 18, 36 hours commence to run at that point in time. Okay, that would be the reckoning point. How about in the hot pursuit? At the time of his arrest, because it says there, we have to deliver within. So the arrest, but the arrest there must be considered to be hot pursuit. So that is the point of reckoning of the 12, 18, 36 hours. Now, you are saying a while ago, what if it is Saturday? Now, take note that if the accused committed the crime or he was arrested prior to 5 o'clock on a Friday, the period commenced to run already. It will not stop at 5 p.m. where the offices, government offices will be closed. It would not stop on Saturday or Sunday or even on Monday, which may be a holiday, but it continues to run. It did not stop because it has already run. But what if he was arrested after 5 p.m. on a Friday? The period shall commence to run only at 8 a.m. the next working day. Okay? So I think that is clear. Now, you might be asking, is this 12, 18, or 36 hours has no exception whatsoever? It has. Like, and this is based on jurisprudence and some regulations or department orders issued. The time of the arrest, that's why there is a leeway. It could be the availability of the prosecutor or the staff, or it could be the circumstance that courts or government offices are closed on Saturday or Sunday. That's why, while the law says 12/1836, there is actually leniency as far as its application is concerned, but the law is the law. So if you are there, a counsel of an offended party later on, you can observe it clearly. Okay, you can always raise, no one is stopping you because the law is very clear. So what shall the police in custody of this arrested person? Because actually the offenders here under Article 125 is not the prosecutor, because we are not the one detaining the person. It is usually the police officer who caused his arrest. What shall they do? If it is impossible to comply with the 12, 18, or 36 hours, What he shall do so that he will not be charged under Article 125? Release the accused. Release him. Same with what we do when we evaluated that the arrest of the accused does not fall to paragraphs 1 and 2, which it's not in flagrante, it's not hot pursuit, it's not hot pursuit anymore, then we release him. But while the police can release the accused so that he would not be charged under Article 125, what he will do is to file the complaint against the accused under regular preliminary investigation filing, which I have mentioned earlier. Okay? Now, by the way, the moment that the police officer already filed the complaint before the prosecutor's office, where the prosecutor's office would docket the complaint against the accused, the 12-18-36 hours is actually suspended at that moment. Okay? It tools the running of the 12-18-36 hours. So basically, we also have made a distinction already of Article 124 and 125. In 124, detention is illegal from the beginning. In 125, detention is legal in the beginning. The illegality only comes in by the failure of the public officer to deliver him to the proper judicial authority. And take note, Article 125 does not apply if the detained person or arrested person is a suspected terrorist. In other words, the crime he allegedly committed is punished under RA 9372, then the provisions under Article 125 of the RPC does not apply, because if it is RA 9372, then the police officer has at least have 3 days within which to present the arrested person within 3 days to the judge residing in the locality. Delaying release, Article 126. The penalties provided under Article 124, so it is still the same. Actually, 124, 125, 126, they are all arbitrary detention. But then in 126, it is just referring to delaying release. So the overt act of the accused here is delaying release, but 124, 125, 126, they have the same penalty. The penalties provided in Article 124 shall be imposed upon any public officer or employee who delays for the period of time specified therein the performance of any judicial or executive order for the release of a prisoner or detention prisoner, or unduly delays the service of the notice of such order to said prisoner, or the proceedings upon any petition for the liberation of such person. Now, what we are referring to in Article 126 is actually the failure or delay on the part of the public officer to release a prisoner or detention prisoner. To illustrate this one, for example, you have there an order by the Honorable Court directing the release of the person either because the charge against him has been terminated already, he has been convicted, or the case was dismissed. So an order was issued by the court. And by the way, the usual offender here under Article 126 are jail wardens, or let us say chief of police who has custody of um, detained person but not yet charged in court. So let's go back to our example. You have there the order of the court uh, ordering the release of the person because the information or the charge against the accused has been terminated already or has been dismissed for whatever reason, and you receive the order, let's say on a Friday, and because you are in a hurry to go home, you are excited to go home, you did not serve it to the detained person. You waited on the next working day, so he is actually overstaying. He spent the weekend over there inside the penitentiary because of your delay in the service of the order. So you can be made liable under 126. Executive order, so it could be, let's say, on our part because we are under the executive branch of the government. So if we found that there is no probable cause, or we ordered that the accused should be released in the meantime because the complaint against him shall be subjected for further regular preliminary investigation, we actually also issued an order for the release of the person. So the jailer, if he failed to release the detained prisoner on time, then he can may be liable. You can make him liable under Article 126. So you have there, wardens and jailers are the public officers most likely to violate Article 126. Now, take note of the third element because the third element requires that the offender, without good reason of the delay, because it could be that the reason for the delay is because of some emergency. So, we can always understand. Okay, so the third element requires that the offender must act without good reason of his delay. So that we can say that it is really intentional on the part of the jailer or the warden. Expulsion. The penalty of prison correctional shall be imposed upon any public officer or employee not being thereunto authorized by law, expel any person from the Philippine Islands, or shall compel such person to change residence. Now, have you noticed from Article 124, the offenders here are usually public officer or employee. Okay? So, they are the most violators of Title II because the felonies referred to in Title II are dealing with your rights guaranteed by the Constitution. Okay? So the acts of the accused public officer here is expelling a person or compelling him to change residence without authority of law. So the offender is a public officer, expels or compels without authority of law. In other words, only the court by final judgment can order a person to change his residence. Okay, this is illustrated in ejectment proceedings, expropriation proceedings, and in the penalty of destierro. What about ejectment? Now take note that in an ejectment case, there is a trial conducted by the judge before the defendants can be ejected from the property or the place we are residing. In other words, before the issuance of that order by the court granting the ejectment case, then you cannot expel one from his from the Philippines or compel him to change residence. Same with expropriation. So after expropriation proceedings by the court, You have there an order granting the expropriation. Of course, if you are there, imuhang property gi-expropriate, once you will be paid, get out from there. Do not stay there anymore. Okay? So, by that expropriation proceedings, then you would really be compelled to change your residence. How about distiero? Remember distiero? Usually this is um, imposed upon an accused who committed a crime, let's say against the wife or the family. So distiero, basically you are prohibited from entering the dwelling or the prohibited place. Now, even if you are the owner of the house, if you are the accused there and you were sentenced to distiero, you would really be compelled to change your residence and you will not be allowed to enter therein as a penalty of distiero. So the landmark case of expulsion is that case of Villavicencio versus Lucban, when the city mayor of the city of Manila compelled these alleged prostitutes to compel them to transfer or expel them from Manila and compel them to transfer in Davao. So that is the case of Villavicencio. Case Section 2, you have their violation of domicile under Article 128. The penalty of prison correctional minimum shall be imposed upon any public officer or employee who, not being authorized by judicial order, shall enter again any dwelling against the will of the owner thereof, search papers or other effects found therein without the previous consent of the owner, or having surreptitiously entered said dwelling and being required to leave shall refuse to do so. So there are actually three overt acts of the accused here. Okay, you have there. By entering the dwelling against the will of the owner. Now take note that the entrance here must be against the will of the owner, and that prohibition must maybe implied or expressed. Implied because the door is closed. In other words, you cannot just enter. Implied because of the time of the alleged entrance, and express if you are really prohibited from entering. Okay? Now, on the next act, searching papers or other effects found therein without the previous consent of such owner. Under the second act, this presupposes that you were allowed entrance. But to search paper, that would be another story. Okay? What you can do there, if you are there allowed entrance by the owner, you're not supposed to search, but you cannot also close your eyes for any contraband that you saw in plain view. In other words, you are limited to plain view only so that you cannot be made liable for violation against domicile falling under or described under the second act. Now, how about refusing to leave the premises? Same thing. This presupposes that the entrance was allowed. It was not prohibited, but when you were required to leave, you refused to leave. So those are the acts of uh, punished under Article 128 for violation of domicile. And Article 128, the crime is qualified, meaning to say penalty is higher if the same is committed in the nighttime, or if any papers or effects not constituting evidence of a crime be not returned immediately after the search made by the offender, and the penalty is prison correctional medium and maximum periods. So to reiterate the elements, offender is a public officer. He is not authorized by judicial order to enter the dwelling or to make search therein for papers or other effects. Okay, so against the will of the owner presupposes of possession or prohibition by said owner, whether express or implied. If the entrance by the public officer or employee is only without the consent, the crime is not committed. It must be against the will. Neither is the crime committed if the owner of the dwelling consented to the owner. Now, actually, this also admits for an exception if the purpose of your entrance there is because you are performing your duties. For example, you are there a policeman and you are pursuing a snatcher, for example, and it went inside. Now, first you have to do is to tell your authority, tell your purpose. If despite that information relayed to the owner, he still prohibits you from entering, then actually the rules also give you the authority to get inside, break in, despite the opposition of the owner because you already told him your purpose. And despite his knowledge, he prohibited you from entering your property. Actually, the owner can also be charged for obstruction of justice. Now, another thing, you could also be allowed to break out to liberate yourself. For example, when you were finally able to get in the house, the owner locked you inside. So you can actually break out to liberate yourself. Okay? When we say break out, you are allowed to destroy. You are justified, actually justified in destroying a portion of the house just to liberate yourself. Okay? Search warrants maliciously obtained and abuse in the service of those legally obtained. Now take note that it is in addition. In addition to the liability attaching to the offender for the commission of any other offense, the penalty of arresto mayor in its maximum period to prison correctional in its minimum period and a fine not exceeding 200,000 shall be imposed upon any public officer or employee who shall procure a search warrant without just cause or having legally procured the same shall exceed his authority or use unnecessary severity in executing the same. So there are actually two acts punished under the provision of the law: procuring a search warrant without just cause, exceeding his authority, or by using unnecessary severity in executing a search warrant. What does this mean? In procuring a search warrant without just cause. Now, actually, when police officers would go to court and apply for a search warrant, they actually prepare documents for that purpose. They would file a petition for the issuance of the search warrant. It will be substantiated or supported with affidavits of the applicant, usually the hepe, and its witnesses. So the hepe or the witnesses would state in their judicial affidavits that there is probable cause that this particular person who is the subject of the search warrant is committing a crime. Hence, we need the issuance of a search warrant in order to get hold of the evidences. And how would you substantiate your allegation? You might say that this accused commits a violation under RA 9165 because he is actually in possession of shabu. And what is your basis to further substantiate your allegation? You will testify therein that on this occasion, Day one, two, three, for example, you made a surveillance against the subject, and you have observed that there are many people from all walks of life, even in the wee hours, going to his residence, and it would not stay long. They just go out, and usually they are riding in motorcycles, blah blah blah. On another occasion, you were able to make a test buy. In other words, a pusher buyer was done to make a test buy, and actually they were able to purchase a sachet containing white crystalline substance. And when this white crystalline substance were subjected for qualitative examination, it yielded positive for the presence of shabu, and you attach to the affidavit the chemistry report. So that would be an example. But if in your application, they are actually all bogus, because you are actually just making some fishing expedition against a particular person, then your act is punishable under Article 129. That is, search warrant maliciously obtained, because there was no reasonable ground or there was no legal basis for the application for the search warrant. Second act. Second act, that is here. Exceeding authority. Now, in exceeding authority, this presupposes that there was legal basis in the issuance of the search warrant, in your application and the subsequent issuance of the search warrant. But the violation comes in because you use unnecessary severity in the execution, or you exceed your authority in the execution or implementation of the search warrant. Example, the subject of the search warrant is for violation under 9165. So, since it is for violation under 165, supposedly or presumably, you can only confiscate shabu, weighing scale, if there is any, because it is used in weighing the dangerous drugs which he would be subsequently be selling. Let's say aluminum foil, tutor, but you abuse your authority in execution if you confiscate something which is totally foreign or different from that of the subject of the search warrant. So, for example, you confiscated a branded shirt of the subject of the search warrant. Okay, so that would be an example. In unnecessary severity, now take note that if you are there armed with a search warrant, the police officers can actually open closed receptacles. Example, you have there a closed cabinet or a closed drawers. The police officers can actually open it, but you cannot use unnecessary severity. So what you shall do? Request the owner, please open it, because you are actually authorized to open closed receptacles. But if you did not, and in fact you just kick him and get a hammer and break open the cabinet or the, let's say, any closed receptacles therein, that is unnecessary severity. There is no need for that, because in fact, the owner or the subject of the search warrant did not even resist. They are even cooperative when you implemented the search warrant. So, remember, I highlighted in addition. So, aside from violation under 129, the police officers could also be charged for malicious mischief, for example. They can also be charged for physical injury if the people therein were harmed or injured in the course of your implementation of the search warrant. And that infliction of physical harm was actually unnecessary. Now, by the way, a search warrant is an order in writing issued in the name of the people of the Philippines, signed by the judge, and directed to a peace officer commanding him to search for personal property described therein and bring it back to court. And what are the personal property that can be subject in a search warrant? Subject of the offense, stolen or embezzled and other proceeds or fruits of the offense, or personal property to be used or intended to be used as a means of committing the offense. So those are the actual uh, properties that can be subject in a search warrant. Now you might be asking, what about fiscal? In the course of the implementation of the search warrant, aside from the fact that the subject of the search warrant is for violation under RA 9165, what if they found a firearm and the firearm is unlicensed? Can they also confiscate it? Yes, because that is a contraband, that consists another violation of the law. And that presupposes that when you confiscated, you discovered that unlicensed firearm, you are still in the process of implementing the search. In other words, you have not found yet the subject personal properties enumerated in the search warrant. Okay, and take note that in the search warrant, it will also specify the place to be searched. And for more details on the search warrant, you will have that in your criminal procedure. You will also learn therein that a search warrant also has a lifespan. Okay, so Article 130, searching domicile without witnesses. So in Article 130, the public officer here in the implementation of the search warrant, because it could be possible that when they reach the house of the subject, they are no longer there. It's either he has escaped or he is really not there. Okay? Presuming he is not there. The implementation of the search can proceed if you have there the presence of any member of the family, because the law says any member of the family in the latter's absence. But what if also the family is not there? Would the operation be suspended because the subject of the search warrant is not around, or any member of the family is not around? Totally, their house is closed. You can still proceed. What the law says, you just have to secure the presence of two witnesses residing in the same locality. But if you fail to secure the presence of two witnesses residing in the same locality, then you will be charged in Article 130. So what then is Article 130? It is searching domicile without witnesses. Now, by the way, when you apply for a search warrant, it is not open to the public. It is actually closed. Why? For security reasons. You know, the walls have ears. It even has eyes. That's why when the police officers are already in possession of the search warrant, when they reach the house of the accused or the subject of the search warrant, they are no longer there. And take note that, and the usual witnesses here are actually barangay tanods, maumay madali-dali, dili sad kabalibad. Why? Because if it is a private citizen, usually the neighbor of the accused, because the law requires residing in the same locality, what can you expect from the neighbors? For all you know, they are beneficiaries from the acts of the accused. He is the Robin Hood in the locality. So si tanod ragay madali. But take note that in RA 9165, the law likewise requires two witnesses in the inventory taking. And what the law says, elected barangay official. So a barangay tanod is not an elected barangay official. It must be at least a barangay councilor or the barangay captain. And a member, a representative from the DOJ or from the media. So you have there two. Here in 130 RPC, it only says two witnesses residing in the same locality. So if you are implementing a search warrant for violation under RA 9165, you also have to comply the requirement there that your witness must be an elected barangay official. Of course, the elected barangay official resides already in the same locality. And how about the representative from the DOJ and the media? Because if it is not from the same locality, you get another one. And then plus the media or the DOJ to comply also with RA 9165. Because these two witnesses is the minimum. Okay. Okay, so you have there the elements. Offender is a public officer or employee. He is armed with search warrant legally procured. That he searches the domicile, papers, or other belongings of any person that the owner or any member of his family or two witnesses residing in the same locality are not present. Exception that there is no need to secure a search warrant for purposes of searching a person if the same is for violation under the Tariff and Custom Codes violation. Okay, that is an exception. But exception to the exception, meaning to say, you really have to secure a search warrant even if the same is for violation of Tariff and Customs Code if the place to be searched is a dwelling house. Okay? You really need a search warrant if the place to be searched is the dwelling house, even if the same is for violation under the Tariff and Customs Code. Section 3. Prohibition, interruption, and dissolution of peaceful meetings. Article 131 provides the penalty of prison correctional minimum shall be imposed upon any public officer or employee who, without legal ground, shall prohibit or interrupt the holding of a peaceful meeting or shall dissolve the same. Now, the public officer or employee here is not a participant to the meeting. The public officer or employee commits the felony if he prohibit, interrupt, or dissolve the peaceful meeting without legal ground. So when you say prohibit, you cannot prohibit them from staging a prayer rally. Prayer rally is a peaceful meeting. In other words, there is no legal ground for you to prohibit them from staging a prayer rally. How about interrupt? With more reason. Nangadji imong samok-samokon, di ba? Same with dissolution. There is no reason for you to dissolve the prayer rally. But if that meeting cease to be peaceful, kay dili lang di ay to siya prayer rally, front lang di ay naa ay laing tuyo. Of course, you have all the right to interrupt and dissolve the meeting because it ceased to be peaceful. The same penalty shall be imposed upon a public officer or employee who shall hinder any person from joining any lawful association or from attending any meeting. Okay, so if you prohibit one, then this is actually a violation against his constitutional right to assembly. The same penalty shall also be imposed upon any public officer or employee who shall prohibit or hinder any person from addressing, either alone or together with others, any petition to the authorities for the correction of abuses or redress of grievances. So, the crime is committed if you prohibit, disrupt, or dissolve without legal ground. So you have there the three acts punished: the prohibiting or interrupting without legal ground the holding of a peaceful meeting or by dissolving the same, when you stop or hinder a person from joining any lawful association, from attending any of its meeting, or prohibit or hindering any person from addressing, from either alone or together, any petition to the authorities for the correction of abuses or redress of grievances. Now, take note that the citizens have the right to join any meeting, to attend, or to hear its grievances, for as long as it would not constitute a violation of any other law. And another thing is that you have to secure a permit. So there's no reason for you to prohibit, interrupt, or dissolve them. Interruption of religious worship. The penalty of prison correctional minimum shall be imposed upon any public officer or employee who shall prevent any or disturb the ceremonies or manifestations of any religion. So there are also two, it is also referring to ceremony and manifestation. The act of the accused here is qualified if he commits if he interrupts the religious worship with violence or threats. That's why the penalty is higher. So an example of this is that you have there a mass that is about to be celebrated in a barangay, uh, in a chapel, and here comes the tanod usually. Kay mo may suguon ni kapitan, maoray madali-dali og sugo ni kapitan, he actually um, interrupts the holding of the mass by, let's say, assaulting the priest. So, as a result, the mass was not celebrated. So, it is a violation here under Article 132. And in fact, the crime is qualified because of the violence, the presence of violence done by the accused in the commission of the crime. So, the offender is a public officer or employee, religious ceremony or manifestation of any religion are about to take place or are ongoing. The offender prevents, kung wa pa nagsugod, or disturbs kung nagsugod na. If the crime is committed with violence or threats, it's qualified. Penalty is higher. Offending the religious feelings. The penalty of arresto mayor in its maximum period to prison correctional in its minimum period shall be imposed upon anyone who in a place devoted to religious worship or during the celebration of any religious ceremony shall perform acts notoriously offensive to the feelings of the faithful. Now, take note that the offender here, the person liable, is anyone. It is not just a public officer or employee. This is actually the only felony in Title II that can be committed by anyone because all the rest are committed by a public officer or employee. And when shall this anyone be made criminally liable under Article 133? If he offends the religious feelings. And 133 actually gives you two places where the crime can be committed. Now, first, place devoted to religious worship. So when we say place devoted to religious worship, so we are referring to church, mosque, chapel, because these are places devoted to religious worship, and the accused can be made liable under Article 133 even if at the time of the commission of the crime there is no actual ceremony taking place. Example, you went inside a church and you desecrated one of the statutes statues of a saint there. Even if there is no mass ongoing, that is that the crime is committed. Now, if it is committed on any other place not devoted to religious worship, the law requires that it must be committed during the celebration of any religious ceremony. So if it is in other places other than that devoted to religious worship, for example, in a cemetery, and there is a mass ongoing for the burial that was held for the burial of a dead person, take note that it was committed during a celebration of any religious ceremony. It could also be during a procession. For as long as your act there is notoriously offensive to the feelings of the faithful, for example, nagsimba sila dito, nagmisa, perting guula, kay namoy namatay. And then here comes you on the other end or other part of the cemetery, nagkanta-kantay noong kay banal na aso pagyud ang imuhang gikanta. Okay rata tug my way, pero banal na aso, it is actually notoriously offensive. Okay, joke lang na, pero that is an example. And it is taken from the point of view of the offended party and not on the offender, because he may have other purpose, but it is taken from the point of view of the offended party. For as long as it is notoriously offensive on their part, then the crime is committed. So, religious ceremonies are those religious acts performed outside of the church, such as processions and special prayers for burying dead person. Okay, so that's all for Title 2, and thank you for your time.